Good afternoon and welcome to today's webinar. And this is our first presentation focusing on a court or a justice and treatment partnership. The focus today is on the Peterborough Community Support Court. And I welcome you on behalf of the International Association of Treatment Courts and the Association of Justice and Treatment Professionals. Now, a few housekeeping things as we gather. The content of the webinars is the sole responsibility of the presenters and do not necessarily represent the views of the IJTP or IATCP. And the panelists will keep their microphones muted, and certainly they will unmute them when they are speaking. Just a reminder of that. Also, we love questions, and we like to engage with you. And so, do not hesitate to use the question and answer icon there. Send us your questions. The panelists will leave some time at the end to enable your questions to be answered. Also, the AJTP and the International Association of Drug Treatment Court Professionals, they do slightly different things. The AJTP looks at all types of justice and treatment partnerships, the goal being to try to create an avenue for the sharing of best practices, ideas, and so on and so forth. The IADTCP does the same thing, except it just focuses only on treatment courts, and it's more international in its breadth. Twitter, LinkedIn, website are ways to know what's going on, and also the website is also a way to get in touch with us. Let us know what topics we want to cover, you want us to cover, or if you've got to know of a speaker, or if you want us to move in a particular direction. We love your feedback. And also, a recorded version of the webinar will be available on the website on demand after this session is over. And a PowerPoint, if there's a PowerPoint, it will be available also on the website. And the Human Services Justice Coordinating Committee is having a conference November 16th to the 17th, and that conference is registration is open for that conference. So that's one of the things that is coming up. Now that enough of us has gathered at this point, I would just like to thank the persons who are helping us to organize this. Jennifer Graham, Andrew Rivard, Kim Briggs, Erin Smith. Thank you. And I think a sufficient number of us have gathered. So Erin Smith will do the land acknowledgement at this time.
Thank you, Justice Burns. So we will begin this webinar by acknowledging that we are meeting on Aboriginal land that has been inhabited by Indigenous peoples from the beginning. As settlers, we're grateful for the opportunity to meet here, and we thank all the generations of people who have taken care of this land for thousands of years. Long before today, as we gather here, there have been Aboriginal people who have been the stewards of this land. In particular, we would like to acknowledge the Anishinaabe, Huron-Wendat, Haudenosaunee, and Ojibwa Chippewa peoples, the land that is home to the Métis, and most recently, the territory of the Mississaugas of the Credit First Nation, who are direct descendants of the Mississaugas of the Credit. We recognize and deeply appreciate their historic connection to this land. We also recognize the contributions of Métis, Inuit, and other Indigenous peoples who have made both in shaping and strengthening this community, in particular, in our province and country as a whole. As settlers, this recognition of the contributions and historic importance of Indigenous peoples must also be clearly and overtly connected to our collective commitment to make the promise and the challenge of truth and reconciliation real in our communities. In particular, we would like to bring justice for all the lives lost in residential schools, as well as all the murdered and missing Indigenous women and girls across our country.
Thank you, Erin. Now let's meet our panelists. Julia Bakker is a justice service worker with the Canadian Mental Health Association, Haliburton, co-author Pine Ridge. She has been case managing individuals through the Community Support Court since 2016. Julia has previously completed her undergraduate thesis work in the area of drug treatment court programs, as well as assisting with the Durham Drug Treatment and Mental Health Court Research Project in 2014 as part of her criminology studies at the University of Ontario Institute of Technology. She's passionate about using a multidisciplinary approach to divert individuals away from the justice system, using strength-based, trauma-informed, and culturally mindful practices. And then we have Bakhtawar Riaz. Bakhtawar Riaz is a justice service worker at the Elizabeth Fry Society of Peterborough. She has been in this role for 2.5 years, 2.5 years. Kate Bertrand. Kate Bertrand is a counselor with 4 counties addiction services team, forecast. She's a court support worker within the Peterborough Community Support Court. She has held that position for 3.5 years. And then Kelly Eberhard was called to the bar in 1999. She is an assistant crown attorney in Peterborough. She has been an assistant crown since 2007, and she was a defense counsel previously. Having said that, I'll disappear and the presentation shall begin.
Hello, my name is Kate Bertrand, and I'm an addictions counselor in the court program role with 4 counties addiction services team in Peterborough. I'm one of the justice service workers on the community support court team, which is what we'll be talking to you about today. This section of our presentation is recorded, so if you miss anything, you'll be able to go back and review it. We will be live at the end of the presentation and have some time for questions. So just before we begin, I wanted to say thank you to Justice Barnes for hosting us, as well as for being one of the true leaders in the field of mental health and drug courts. Our agenda for today. First, we are going to provide you with an overview of the Peterborough Community Support Court. You might hear us refer to this as CSC throughout. And then, for the purpose of this presentation, we've broken down the court process into 4 easy steps. We hope this presentation can work as a practical information guide on how a concurrent disorders court can run, even during a global pandemic. Then, at the end, there'll be time for questions. A brief introduction about Community Support Court. Community Support Court is a mental health and substance use court, or called a Concurrent Disorder Treatment Court, that operates out of the Ontario Court of Justice in Peterborough, Ontario. It was created in 2011, meaning we just celebrated our 10-year anniversary of this court. The court started as there was recognition in the community that many people coming through the court were dealing with addiction and mental health concerns, and there needed to be another way to address this. So several agencies got together, and that started the development of the Community Support Court. We are an unfunded court, which means we get no money other than a $500 donation yearly from our local HSJCC. In this court, we support individuals who self-identify as having a mental health concern or a substance use concern and have come into conflict with the law in some way. So we identify the link between their substance use or mental health concerns and how that led to a criminal charge. We do have a ton of policies and paperwork, and we're consistently reviewing and adapting these to make sure our court runs as smooth as possible. So if you are looking for more information on that, we do have a website as well called peterboroughcsc.org. The next two slides are about our principles and objectives. I won't read through all the principles here. As you can see, it's quite lengthy, but we thought we'd include it on the PowerPoint in case anybody wanted to take a look at those after. We are recognized by the CDSA as a treatment court, which allows to kind of bypass mandatory minimums that might still exist, but we won't typically look like a mental health court where you might see a psychiatrist doing NCR assessments or fitness exams, and we won't look exactly like a funded drug treatment court. So we fall somewhere in the middle by being a concurrent disorders court. And what this allows us to do is capture and support more people that might be dealing with complex issues that aren't exactly specific just to mental health or just to substance use. We're really able to take philosophies of mental health courts and philosophies of drug courts and combine them into our own unique court that we hope can support a large number of individuals. And we'll talk a little bit more about that at the end, but our ultimate goal really is rehabilitation over incarceration. This slide outlines the 4 steps that we're going to go through today in the presentation. The first step is connection, so how we connect with participants. Step 2 is the application process. Step 3 discusses entry into the program. And step 4 will show you what a typical community support court day will look like. I'm going to pass it over now to my colleague Bakhtawar Riaz from the Elizabeth Fry Society of Peterborough to discuss step 1.
In this section, we will talk about the agencies involved, how referrals work, how we screen for CSC candidates, and we will touch on some of the changes due to the COVID-19 pandemic. Participants in CSC are often connected to one of the 5 agencies that provide justice services in the Peterborough area. These agencies are Four Counties Addiction Service Team, or Forecast, Nogo Friendship Center, the Canadian Mental Health Association, the Elizabeth Fry Society of Peterborough, and the Salvation Army. The Nogo Friendship Center also runs an additional Indigenous court diversion program, which runs parallel to CSC. It recognizes that an individual does not have to present with an addiction or mental health concern in order to participate. Each agency will have their own agency intake process, but each can refer to CSC. It's expected that the participant will be connected to one of these 5 agencies. There are several ways that an individual can be referred to community support court. Most often, clients for community support court are referred either by duty counsel or private counsel, or identified as a good fit for community support court by their justice worker. The justice worker, in collaboration with counsel, submit an application to the Crown for community support court. Referrals can also come from probation and parole or other community agencies. A good fit for CSC is an individual who has either substance use and/or mental health concern that they are willing to address and receive treatment for. Some of the goals of CSC are to connect individuals with community supports to address undiagnosed mental health or substance use concerns, and to make the court process empowering and supportive one, rather than one focused on punishment. Often individuals are able to enter CSC and see a different side of the criminal justice system. So COVID-19 has presented its own challenges and has changed some of what we do. Prior to COVID-19, the justice workers were present in the courthouse for outreach and to accept referrals. JSWs were able to meet individuals and duty counsel in person, discuss CSC as an option, and complete and submit applications. There were also posters of CSC in the courthouse, and individuals were welcome to ask questions about CSC as an option for them. But with the court closure due to COVID-19, it's been difficult to catch clients. Some folks don't have access to phone or internet, and agencies are open in a limited capacity. Each agency worked within their own COVID-19 regulations to work on ways to minimize barriers for our service users. And we're also working on ways to make CSC better known among referring agencies, such as duty counsel. Currently, the justice workers are present in the case management court via Zoom throughout the week and can be placed in a breakout room to connect with individuals.
Good afternoon, everybody. My name is Kelly Eberhard. I'm an assistant Crown here in Peterborough, and I've been involved with the Community Support Court since the beginning, 10 years ago, and it has really been an amazing journey. I'm going to speak at this point on the application phase and where that may lead. I will give an overview of the different tracks of our court, some forms, application forms, treatment forms, the entry, what happens, how does someone get in, how is someone excluded, and what happens along the way of each individual journey in Community Support Court. As you can see, under the Community Support Court umbrella, we've got 4 different tracks: court support, diversion, track 1, and track 2. Essentially, our justice service workers will work with anyone who fits the mandate of their agencies, and it's the Crown who decides which track, which of the 4 tracks an accused will journey through. But ultimately, it's really the accused who will demonstrate whether or not they are capable and or willing to undertake and complete the journey. All of the labor-intensive front-end work that our justice service workers do for anyone charged with a criminal offense, no matter whether they are officially in Community Support Court or not, is called court support. Anyone can take advantage of Community Support Court, even if they're not looking to get into the official court process, Community Support Court process. So, for example, an accused could be charged with an aggravated assault, a charge that on its face is not eligible for Community Support Court because of the seriousness of the charge. But our justice service workers can and still do provide community support for them. So they help access supports in the community. They help them connect into the virtual Zoom world and Zoom courts. And for those who don't have a home, let alone a computer or a smartphone, this really is an invaluable assistance. Now, that court support can then lead into officially being accepted into one of the 3 more official Community Support Court tracks. That is diversion, track 1, or track 2. And this is done through an application. So the journey into Community Support Court begins with a consent form that's signed with the individual agency, which you can see on the left-hand side of this screen. And that could be Elizabeth Fry, CMHA, Forecast. And then we go on to the application process. Now, and that's seen on the middle to the right-hand side of the page. There's no magic, actually, in our court in which agency or justice service worker assists with the application. In fact, the justice service workers often trade off clients. For example, say a worker from the CMHA takes someone in, they start speaking with them, they think it's an appropriate application, but really the main and crucial issue for that particular person is, for example, an addiction to crystal meth. And so they will correspond with the Forecast addictions worker, addictions counselor, and that addictions counselor can very well take over the application and take over the supervision and treatment and planning of that particular person. So it may be difficult also to see on this slide, but in the application form, we have slightly altered it because of COVID, just above where the accused is supposed to sign. And in pre-COVID days, they actually would sign on the dotted line. They now have a box that can be ticked, basically to show that they agree about this application form being made. It speaks to 11B rights and the waiver, and that they agree that the Crown should consider the application. Very important to note, as a Crown, I don't consider applications for the most part until I actually get an application, because too often I've been fooled by the enthusiastic lawyer who says, oh, I think my client would be really great for community support court. I get excited about it. They get excited about it. Person gets into community support court. They don't know what community support court is. And in fact, sometimes they have no desire to be in community support court. So I wait until the application form is filled out. The diversion track. So diversion is our lowest level of intervention in community support court. Typical offenses are low-end property, administration of justice offenses, low-end assaultive behaviors. Doesn't matter if you have a criminal record or not. These are typically take place over the span of 4 to 6 months. Ultimately, the charges are withdrawn with or without an 810 bond or a common law bond. Essentially, on the federal side, it's noteworthy that these offenses in this track have essentially dropped off to nothing because of the current federal policy to withdraw and not proceed in prosecuting simple possession charges. So in this diversion track, it is just the provincial crown. Track 1 is our middle road. When the charge is more serious or the criminal record speaks volumes, I will approve for Track 1. If community support court weren't in the cards, the Crown would generally be looking at a jail sentence in the intermittent range, up to 90 days jail. In this track, the accused enters a plea, completes the program, and if successful, it is a joint submission for a non-custodial outcome. And we have been known, if the client really wows us in the execution of their treatment plan, to request that the plea be struck and then withdraw the charge. Remember, this is a concurrent disorders court, so it doesn't matter if it's mental health, addictions, or a combination of the two, as long as the treatment plan targets the very reason why they ended up in criminal court in the first place. Track 2 is our version of a drug treatment court. We respect the 13 principles. We have urine screening, incentives, sanctions, a multidisciplinary team meeting, etc. This is our high-intensity court. And this track is reserved for people who are facing the prospect of 90 days in jail or more, often more. They enter a plea at the beginning, and they are required to come to each and every community support court day. That's every first and third Friday of the month. On average, our Track 2 lasts 12 to 18 months, and if successful, they will come out with a joint submission for a non-custodial sentence and an official graduation ceremony. And paperwork in our court. If I haven't mentioned it already, we have tons of forms and paperwork in our court. We are always revamping and coming up with new and hopefully better ways of doing things. And most of it is available on our website. If you don't find it, we have it. So please contact us and we will be happy to share. So in Track 2, this is no exception. And the justice service workers, in consultation with our multidisciplinary team, come up with and progress through some amazing plans. Our multidisciplinary team is, like most other drug treatment courts, comprised of a psychiatrist, probation, judge, lawyers, justice service workers, their managers. We should have police on our team. We have tried over the years to have them involved, but we really just yet haven't been successful in capturing their attention consistently yet, but we really do need to keep on trying. And what you see here on this screen is an example of our community treatment intervention plan. Upon entry into Track 2, we have a waiver form that we've created in consultation with the Toronto Drug Treatment Court and the Durham Drug Treatment Court. Now here I'm going to do a shout out to Jocelyn Boisonneau. You helped us back then and you have helped us so many times since. So an accused will go over this waiver form in detail with their lawyer or their duty counsel. They will also be subject to a community support court bail. Now, Track 2 is a labor-intensive activity for everyone, not just the accused. We have a cap of 8 people in this court. We have gone higher at times, but honestly, it was just too much, and our multidisciplinary team and our justice service workers can only support so many people at this high intensive level. Currently, we only have 2 people in our Track 2, and this is one of the side effects of COVID. It is harder to make connections in this virtual world. We don't have as many applications to community support court as we did pre-COVID. And frankly, the positions taken in the normal court are so low sometimes these days that, based in part because of the Crown's bid to resolve matters outside of trials, to decrease that snowball effect that COVID has created. That in conjunction with the sentencing in this era of COVID in jails is often much lower than pre-COVID times. I really believe that a lot of people might shy away from community support court because they don't feel it's worth the effort. And it is an effort to be in our court. Sometimes outside of community support court, they can just do a few mitigating things informally and get a similar result. So actually, this would be a great thesis, a great research project if I was still a student looking for a topic to write about. I'm no longer a student, but it's definitely interesting phenomena nonetheless. Now I'm going to speak to entry into community support court, how to get in, what will keep you out, and what happens on the ground once you're officially in. At the beginning of our CSC creation, when we were just figuring out how things would work a decade ago, we realized early on that we needed a gatekeeper. We needed one person to keep track of who was coming, who was going, and everything in between. Otherwise, we thought that people could take advantage of gaps in our systems. The role of gatekeeper is really best suited to the Crown. Whether you are a provincial Crown or federal Crown, you are responsible to foster not only the integrity of the court that you're in, but also you owe the entire administration of justice, as always, your good faith and efforts. Essentially, in order to be considered for our court, a candidate must take responsibility for the offense and have either A, as you can see on your screen, a substance use concern, a mental health concern, and/or developmental or intellectual disability. Or you could have a combination of any of those 3. And these issues must then be linked in some way to the commission of the offense, which brings them before the court. Now, once this state of affairs is established, the gatekeeper needs to look at the actual offense or offenses charged and whether or not it is within the list of excluded offenses, which you can see on your screen to the right. Now, I'm not going to tell you that we've never had a residential break-in, because we have. And what that means is that sometimes there are exceptions to the rules, but these exceptions are rare. Now, when the case is being considered by the gatekeeper, special attention needs to be made to the victims of offenses if they are present. In our case, I always reach out to the victims. Now, I'm not always successful in getting in touch with them, but I would say 90 to 95% of the time I am. I explain the situation, that an application has been made to Community Support Court, what Community Support Court is. I then tell them I make the decision, but I give them an opportunity to provide input if they wish. And in my experience, 8.5 to 9 times out of 10, the victims are in favor of the accused participation. What we see here now on this screen are the treatment plan forms for diversion and track 1. So whichever justice service worker from all of our agencies that an accused ends up with, all workers have training in and have access to both mental health and substance use resources. Because keeping in mind that Community Support Court is that concurrent disorders court, so we don't exclude one or the other, that is substance use or addictions or mental health, because what we find is that most people have both issues that are happening concurrently. And as a gatekeeper, when making final decisions about whether or not people will come into our court and be able to take advantage of treatment plans like we see here, public safety and the integrity of the court will figure in strongly into the decision making. And sometimes a couple nights sleep helps to make the decision clear. And once that decision made, we have the treatment plan. So in working with the client, once accepted, the justice service worker will complete some assessments and they'll have some initial sessions and come up with a plan. This form is what we use for diversions and track 1s. Each community support court, the justice service workers send these forms all filled out. Now, the first couple boxes, the diagnosis and the treatment part, they stay the same, but the update will of course change one community support court day to another. So they send those forms in to me, the Crown, a couple days before the actual community support court. I will then forward those on to the judge via the secretary. And this system works really well for us because on the actual day of community support court, we all feel comfortable about the current state of affairs and the follow-up that has happened in the 2 weeks prior with that accused. And then we can adequately address on the record without too many surprises. This slide that we now see shows our treatment plan for track 2. And this is our form that we use. And as you can see, it's a little bit more involved. It shows there are columns for incentives received, sanctions received. And if anyone is interested in having a closer look at these forms that we have shown here today, or any other forms, please feel free to access our website or be in touch with us. We're very happy to share. I should also note that for those crowns in the crowd, I don't tend to fill Scope, which is our electronic system, in with the very personal and private details that are given to me on a regular basis from the justice service workers. This information should be for for community support court purposes only. In the old days of physical files, I would have a separate file, but now I just keep a OneNote document on our P drive so that I can have access to it, and it wouldn't be available to other crowns from other offices in other jurisdictions. The last thing that I will talk about is statistics. I keep them. I have kept them since 2011. I have an Excel spreadsheet, as you can see here on the screen. that is an example that I have screenshotted for you, with the exception of a few columns to keep personal information at bay. But I really wanted to show you that you can see on this screen that we have the different tracks: graduated, track 2, current, track 2, not completed, tracks 1 and 2, etc. And so when a person comes into community support court, I input them into the correct tab, and when they graduate, I fill in the blanks. And we keep track of first appearance dates, and when they're in community support court, when the length of the track, when they finish, number of appearances, what their actual disposition is, whether they have counsel, and probably most importantly, are they committing further offenses while they're in community support court, 1 year post the community support court, and 2 years. What's their main issue? Is it mental health or is it substance use? Now, Scope makes keeping statistics a lot easier than when we used to have the paper files. However, I'm not going to lie, it's still a pain and it's a time-consuming activity. That being said, keeping stats is so important, and it really helps to evaluate what we're doing at the end of the day. We have used these statistics to evaluate our program and to understand what we're doing right and what we could really improve on. We did have a student a couple of years ago from Trent University who did a fantastic research paper on us, and she used these statistics. So it was very helpful to us in looking back on our program and looking forward how we could improve. As an aside from all of this that I've talked about within community support court, if an applicant is not accepted into community support court, the official programs, then they will continue on in the regular streams. And the justice service workers will likely continue to provide their court support, but simply outside of our official community support court time. And this concludes the stage 3, the entry phase. Thank you very much for listening.
Next, we're going to look at step 4, a typical community support court day. In this section, we'll outline the day for you. We'll look at how COVID-19 has impacted what the day looks like, and then some special considerations if you're thinking about starting a concurrent disorders or mental health or drug treatment court. Community support court runs on the first and third Friday of each month for the full day. Diversion and Track 1 participants don't always have to attend every court date, and the justice service worker will work with the Crown to decide when it would be best for them to come back. For Track 2 participants, they have to attend every date. This outlines what a typical community support court day would look like. I'll first discuss it as if we were still running in person, and then I'll talk about what changes we've had to make due to the ongoing COVID-19 pandemic. So we used to meet at the courthouse at 8:30 in the morning for our first morning meeting. The Crown Attorney would attend, court workers, defense counsel, and duty counsel to meet off the record to discuss diversion and Track 1 matters. We would give an update to the Crown Attorney, discuss any issues that need to be worked out, discuss potential sentencings and other things at this meeting. Then at 9:30 would be diversion and Track 1 court time. So that's when the participant would show up. They would then appear in court in front of the judge, and the worker supports them through this whole process. Their matter is either adjourned or completed at this time. And there was no schedule of when people could show up. We encouraged them to get there as early as possible. And we also knew that if someone had higher needs and needed their court matter dealt with right away, we would try to accommodate that. Next, we would have a 12:30 meeting. So the 12:30 meeting is the multidisciplinary team meeting, and this is where we discuss all of our Track 2 participants. The whole team attends. So all the workers in the first meeting, but as well as the judge, we have a psychiatrist, we have team leaders come, and it's an opportunity for everybody to give feedback on those Track 2 updates and decide what the next steps are. Then, after the end of that meeting at 2 o'clock, the Track 2 participants appear in court with the support of their worker. For Track 2, each participant has to stay until every participant's matter has been addressed in court. Due to COVID-19 and the closure of the courthouse, we've had no in-person community support court dates, and everything has moved to over Zoom. So this can create barriers for individuals that potentially don't have a phone or have a computer. We try to address this by either providing them a cell phone through one of the agencies or having them attend the agency of their court worker to get support to call into court. We've also now created a tiered system where each court worker has a set time where their specific participants call in. It allows for less wait times on the phone for participants and know that their court worker will be available during that time they call in. Why we chose a concurrent disorders court. So like I said before, a concurrent disorders court captures both aspects of a mental health court and a drug treatment court and puts them together. And we recognize that many people coming into the court system are not just dealing with one or the other. They can have a treatment plan that only addresses one or the other, but we know that often mental health and substance use can go hand in hand. So we think it's best to kind of treat them at the same time when we're doing our court treatment plans. It also allows us to be more flexible and really address what the individual needs, as well as get them connected with the appropriate resources. Some special considerations if you are considering starting a mental health court, a drug treatment court, or a concurrent disorders court. In community support court, we know that the participants that are coming in often have a lot of things going on in their lives. And it's important to be aware that the court might not always look like a typical court. So people might come in late, people might show up under the influence or experience a mental health crisis. There can be lots of things going on, and we want to be patient and adapt and be understanding of how they've come in that day and appreciate that they've made it to court. Having court staff that understand mental health and addiction is also vital in these courts. And this even comes down to the clerk, the court reporter, duty counsel. When the person feels they're not being judged, it makes for a much better court experience and allows the court to go smoother. Another piece of feedback we often get from participants in community support court is how important the relationship with the judge was. Oftentimes they leave community support court feeling like this is the first time in their court process where they felt really understood, where they felt listened to, and where they feel like the judge really had their best interest. And this can be the judge giving them positive feedback. It can be them wanting to show up to engage with the judge. It can be that that judge gave them extra time to talk in court and just listened. But it's one of the big pieces of feedback we get and is so important. The last point I want to make on this is the importance of being able to be flexible. Like I said, we don't know how someone's going to show up that day. They might need extra support. They may need to be connected to resources in that moment. The times might need to be changed around a bit. Having patience and dealing with the unexpected and being flexible is so helpful in these kind of specialized courts.
Okay, Julia, I have a question. Can I ask it?
Yes, ask away.
Okay. So, would there be a need for this court if possession of drugs was not a crime for your court?
Yes.
Did it exist?
The short answer is yes. I think, as Kelly alluded to briefly in the presentation, because simple possession charges aren't being prosecuted in the same way, we're not seeing as many of those come through court. In maybe Kate, the addictions counselor, could speak on that a bit more, but there might not be as many diversion low-end treatment plans for that. But certainly, again, because we are concurrent disorder, and a lot of it could just be mental health, or sometimes things like intellectual disabilities or FASD, or, there's just a whole host of other reasons. Homelessness is a big one that we're seeing too, that people are interacting with the justice system besides substance use, and how we're prosecuting or charging for that.
Okay. All right. I have another one, and I encourage people to use a Q&A if they have got any questions. I have another one. Now, do the judges and the lawyers and so on and so forth, do they take over treatment? Do they actually listen to the treatment providers, or do they sort of take over treatment and force people to do things they don't want to do?
Do you want to answer that, Kate?
Yeah, I can take this one. I think we've been really lucky in our court that the working relationship between the court workers and the judges, the crowns, the duty counsel, is that we have really good communication. So I feel from my own experience is that the lawyers are really listening to us. The judge is really listening to us and taking our feedback. And oftentimes you hear them actually say in the court, like, the justice workers know the treatment plan side best, so we'll follow through with what they're saying.
Okay. All right. And then another question I also have is that Kelly talked about the fact that there's a graduation, like people go through the process, and then if they succeed, there's a graduation and stuff. Well, what happens if, let's say, I'm a person who have a high needs person, and given the nature of my issues, I'm going to be struggling for the 11 or 12 months. I mean, what if I'm never going to graduate in terms of being able to stop drugs completely? I mean, what happens to me?
So I can answer that in a couple different ways. A lot of people, whether it's diversion or track 1 or the full track 2 program that they've graduated from, oftentimes their continuing supports, that's one of the biggest things I think that people get from being connected, whether they never or even accepted into support court, or they've done the whole process, is now they're connected to supports and resources in the community they weren't before. But often part of their treatment plan is ensuring that they have longer term case management or resources in the community, because we know that, yeah, it's not a short-term solution, and that some people are going to need support sometimes for the rest of their lives. And in addition to that, I know that's something that the case managers have struggled with, and myself, when you've developed a relationship with someone for a year, up to 2 years maybe, and in the track 2 program that is more intensive, and maybe they've done a lot of really good work, but they couldn't get to that official graduation. Our CSC steering committees met and talked about that, and have now implemented new ways to sort of celebrate their success, where they might not get, the full, I can't remember all, like, the graduation's typical ceremony and certificate, but we're still going to honor and recognize all the work that they've done as well.
And I had a question for Kelly. I see we've got a question. This is my last question. I'll shut up. Kelly, you talked about if somebody finishes, they get a non-custodial disposition, so they don't go to jail. So what if I'm the kind of person that Julia has described? In addition to, I've been in the program for so long, I've done all this stuff, I'm having struggles, this is going to be a lifelong thing for me. Does that mean I go to jail because I didn't finish?
It's a great question, Justice Barnes. I'll focus on track 2, for example. As Julia mentioned, we have our full-blown graduation ceremony, but then if, for example, they haven't quite completed, we may have a ceremony and it's basically for a substantial completion. In your Honor's question, you mentioned the possibility of them actually going to jail as opposed to having a joint non-custodial disposition. It really is circumstance dependent. It would depend on the charges. It would depend on how long they've been in our community support court, how much mitigation they have done up to a certain point. When they no longer can or want to continue. It would depend on whether or not they have new outstanding charges. Perhaps they've reoffended in some way. So there are a lot of variables that affect the answer that I would provide to Your Honor to that very question. But certainly there is good case law out there. I believe there's one major one from the province of Alberta that really mandates and directs courts to look at the mitigation that has been done while that person is in a drug treatment court or community support court. And a court must take that into consideration, even though they haven't successfully completed the program. But it's very, very, very rare in our court that we would ask for jail if the person has spent a substantive amount of time in community support court and not completed it. I'm trying to think of a case, but I actually can't. There may have been one or two, but again, it's very individual, case specific dependent.
All right. I noticed the question. Julia, I noticed it looks like somebody had a question.
Okay, yes, I'll read it out right now. So it's from Deanne Bolton. Special circumstances of understanding and patience and trust being developed sounds like you find special people. How do you find these special people? And is peer support something that would be helpful too? The courts have helped me a lot over many years. Thank you. So I don't know if Bakhtawar or Kate have anything more to say. I can just briefly indicate that to your point about the peer support, I would 1000% agree with you that that is incredibly beneficial support for people that are going through the justice system. And it is something we have at CMHA and certainly something that we would refer to people if they felt like that was a benefit or they needed that extra support. And I think it's something that more agencies are getting funding for. Elizabeth Fry Society now has an addiction peer support worker, as well as our local Nogo Jiwanong Friendship Center has a mental health peer support worker now. We have talked about piloting the idea at one point of having someone specific for courts, just not something that we've done, but it would be incredibly helpful to have. In terms of finding the special people, I'm not sure exactly if you're meeting clients, but I don't know if maybe Kate, do you want to answer that?
I can speak to our team a little bit. I'm not sure if it's meaning participants or staff, but we have an advantage right now that the staff that are in community support court from the various agencies have actually been there quite some time. I think this is the longest period of time we've actually had consistent staff. So I think Julia's bio said 4.5 years. I've been there 3.5, Bakhtawar 2.5. And then other members of our team, like Kelly, have been there 10 years. And that consistency is really helpful. We all have really strong working relationships with each other, which then reflects onto the work that we do with our clients as well.
Okay. Julia, I have one question, one last question for you. Uh, when we think about a court process, we think about people getting arrested, they get charged, they go through the system, they may have addictions or mental health issues, and so on and so forth. Lately, those of us in the justice system have been hearing a lot about a trauma-informed approach. And what does that mean, and how does that fit in your court?
Not an easy one to answer, but it's certainly something that I think over the last 5 years, especially, most community addiction and mental health agencies are trying to take this trauma-informed approach when working with individuals. And I think in a nutshell, it's essentially being mindful and informed that there can be a whole complexity of circumstances that have brought someone in to become involved in the justice system and or have impacted the reason why they have addictions or mental health. And I always think of, when I start talking about trauma and addictions, the Gabor Mate quote that not everybody that has suffered trauma will have an addiction, but almost everybody that has addiction has suffered some form of trauma, which getting to know individuals over the years is certainly something that I think you can come across, and sometimes you don't see it right away, and when you start to develop a relationship and get to know someone, that can definitely present itself. So I think it's just, again, we try to take holistic approaches to the treatment plan. And so being trauma informed of seeing where someone's life has maybe led to their involvement in the justice system in that holistic way is going to help how we respond and interact with that person.
Okay. All right, I don't see any more questions. It looks like, all right. Julia, Kate, Bakhtawar, and Kelly, I had place cards to sort of make sure I didn't miss anybody as I was thanking you guys. And I seem to have mixed them up, but we want to thank you very much for a great presentation. You gave us a sense of how your court operates, and what was great actually is that you actually have a model that tends to encompass all forms of intervention in one place. And it's something that we can all learn from. So we just want to thank you very much for your presentation. Your recorded presentation will be on our website, and we certainly will be in touch with you again. Having said that, thank you and good afternoon to all. Thank you.